Okay, hello and good morning, everyone. Welcome to the second day of the online forum on modern direct democracy. This week we were supposed to take place in Bern, Switzerland, but of course, given the current situation, we're holding the first ever online global forum on modern direct democracy. So this is going to be more accessible than any other forum we've had before, but we of course look forward to seeing you next April in Switzerland. Just a short overview of the day first before we begin, and a few technical points. I'll be the technical moderator, so any issues you have, you can let me know in the chat, or I'll let you know some links. You can join some Telegram groups as well, and you can also let us know there. First, short overview of the day. We'll be starting the session today with a briefing on international dimensions of participation, Swiss inputs to bridging the gap, and that will last until the latest 11:30. Then we will break for lunch, and we will have a panel on Corona dictatorships starting at 2 o'clock this afternoon. Half an hour after that, at 16 o'clock today, we'll have a workshop on the Citizens Convention on the climate in France. And this evening, then at 6:30 p.m. until 8 o'clock p.m., we will have a panel on the question, can a World Citizens Initiative help strengthen the UN? So that's our overview for the day. And right now we'll start with the first one on international dimensions of participation, the Swiss inputs to bridging the gap. Before I hand it over to Bruno Kaufmann, who's our content moderator, this is a participatory event, so we of course invite you to put any comments or questions forward. You can use the chat option for that, so everyone has an option that should be in the bottom right-hand corner of your Zoom screen. You can also raise your hand, so there's an option there just under the participants list where you can virtually raise your hand. Yeah, we invite you, of course, to turn on your camera so we can all see each other as well. So for now, I'll hand it over to Bruno, and please look in the chat for any relevant information, the technical, the groups that you can join on Telegram.
Thank you very much, Daniela, for this introduction, and welcome everybody to the second day of the online Global Forum on Modern Direct Democracy. I'm Bruno Kaufmann. I'm one of the co-presidents of the Global Forum. I'm very happy to be with you here today. It's an online forum where we can see each other, when we can talk to each other from long distances. But of course, still we are real people. So today I have the privilege to be in the headquarters of the online Global Forum here in Cologne. And somebody said to me before here in the other room, are you a real person? We only see you online nowadays. So it's really great to also see, of course, each other. And we really hope that next spring we will have the Global Forum on Modern Direct Democracy on site in Bern. It will be possible again, but we don't have to wait for that. We really can be in touch. We really can work together. And this online Global Forum is a great tool. It's a global forum, but of course, democracy, as it is the main issue of this forum, direct democracy, participatory democracy, it's something which is going on in many places, in many cities, on the local level, in countries, but also, of course, within projects run by individual groups, by social movements. So in this week of the Global Forum online, we will learn about many different approaches. And today we will have a real global approach, an international approach in this session, because of course, democracy has become very much as a global issue in recent decades, from being the exemption to being basically the rule. We have seen an extension of democratic principles, practices, and procedures all over the world. And this leads to a very paradoxical situation where on one side, there has never been so much democracy as today, so many people who have the right to vote, to participate, to make their voices heard, but also so much questions, so much movements who are questioning certain aspects of democracy. So at the same time as democracy is winning, it's also losing. And this tension, of course, is a fundamental element of a free democratic society, that everybody has a right to say what she and he wants to say. And this creates a lot of, let's say, need of dialogue, need of institutionalizing democracy. And here we are, of course, facing a big challenge when it comes to the international level, because the international level by tradition has been the level where governments, where ministers, where specialists are meeting, making decisions, agreeing on certain conventions, but where basically the public, where the citizens themselves had very little possibility to influence. At the European Union level, we have seen a development from this classical international level to a more, let's say, transnational democracy level, where citizens also have a right to have a say, where they can vote for a parliament, where there are transparency laws. So there we have seen a certain development of the internationalization, of the transnationalization of democracy. And as you have heard from Daniela before, there are also ideas of creating forms of agenda setting tools at the global level through, for instance, the World Citizen Initiative, which will be the subject of a workshop later today. But what is interesting, of course, in this sphere as well, is that national governments are more and more faced on one side with being part of an international community, which traditionally hasn't been very democratic on one side, and on the other side with their own political system, with their own society, where democracy is the rule, where people want to have a say. And this tension is a very interesting tension because it creates new ideas how to bridge the gap between domestic democracies and the international sphere. And that's the issue of this session we want to discuss, especially how can this gap between democracy at home and less democracy or different kind of democracy or non-democracy at the international level be gapped. Switzerland is, as this is part of the Swiss track, of course, a very interesting example. As Switzerland has a very extensive format of participatory democracy at the national level, at the regional and local level, through direct democracy, through the initiative and referendum process, where also since 1921, big international treaties are the subject of national referendums. And most referendum days, most voting days in Switzerland, there is an issue which links to the international sphere. For instance, this coming weekend, there will be a vote on free movement in Europe. How Switzerland looks into that. We have had dozens of this kind of votes. So you can say that foreign policy is also in that way always domestic policy, and foreign governmental action has also to be linked to a domestic, direct democratic and participatory approach. And for this reason, we want now to discuss this, how Switzerland is dealing with this tension, how Switzerland thinks about how to influence or how to input the international sphere based on its own a rather participatory and direct democratic tradition. And for this, I'm very happy that one of the leading persons at the Foreign Ministry of Switzerland at the Department for International Law is joining us. His name is Roger Dubach. I will briefly present you before I will give you the floor. You studied law at the University of Fribourg and philosophy at the University of Louvain-la-Neuve in Belgium. And in 2003, you joined the diplomatic service of the Federal Department of Foreign Affairs in Switzerland. From 2016 to 2018, you served as diplomatic advisor on G20 issues in the cabinet of the OECD Secretary General in Paris. And you were then appointed as an ambassador at the through the Federal Council in Switzerland in August 2018, and deputy director of the Directorate of International Law. So you're very well suited to address this issue. And I would like to welcome you, Mr. Dubach, and also I would like to give you a few minutes to introduce your basic thoughts, which then we will be able to discuss and also to discuss with all of the participants at this online forum. Good morning, Mr. Dubach, and you have the floor.
Thank you very much. Thank you very much, Mr. Kaufmann, for this very good introduction to the topic. And so I will give you a kind of oversight from Switzerland on this topic. I will start with a kind of a showcase we had in Switzerland, and this was almost 2 years ago. In 2018, the Global Compact for Migration. Perhaps some of you are aware of this compact. And so many governments agreed on this Global Compact for Migration, and it was seen as a good step in achieving the 2030 agenda. And for governments, it was a success. And there was nothing special about this Global Compact for Migration. It was a legally non-binding instrument, mainly with recommendations. So there was, from a government perspective, no issue. But in Switzerland, suddenly there was a big attention to this Global Compact for Migration in the media, and then a big public debate. And this debate was taken up by the parliament as well. And so the perception was that migration policy is very much a domestic policy. And many people thought there is an intrusion from the international level to this domestic policy issue. And as you are aware, migration is, of course, politically sensitive. And so the debate was that the parliament said, about migration, we need to have a word on it. So it's not possible that the government is going to sign and ratify there's no ratification, just to sign such an instrument without having the opinion or the view of the parliament. And this was the start of a bigger discussion on soft law, as we call it. I mean, all these instruments on an international level, sometimes also national level, but all these instruments which are not legally binding, we call them soft law. Perhaps I can go deeper into that if there is an interest in it. And so the parliament in 2019 tasked the government, our government, to draft a report on soft law and the involvement of parliament specifically in soft law instruments. So we published this report by summer 2019. This is a public document where we tried to understand the phenomenon and also came up with some proposals to better involve parliaments in these processes. Now, this discussion of legally binding, non-legally binding, I mean, there's a long history I think in every state about how to deal with it. Of course, there's also the discussion about the balance between legislative and executive power. And from a government perspective, the topic is very sensitive somehow, because we see very well that there is perhaps a lack of participation in this kind of processes. On the other hand, governments need a kind of a flexibility. And as we are living in a fast changing world, if they are too long processes to give a view on such instruments, it becomes also difficult. All in all, and now I will switch to a first slide. Before giving some ideas, we really try to better understand this phenomenon. So I will talk now about for 2 minutes how we see this phenomenon of soft law. Just a second. I hope you see the screen. Okay. So in the end, it's about how to understand regulation in the 21st century. And there we see a kind of a shift in paradigm. My first message is very simple. the international order as it was established after the Second World War, and which is seen as the multilateral world we all know, has no longer the power to regulate or structure the current international dynamic. And therefore we see new phenomenon. And this shift in paradigm, we see, I would like to present you 4 characteristics, which you see on the slide. So the first one, fluid and complex interconnection. This means we live in a dynamic world, and the international treaty world is too static for this world. If you're taken as an example, artificial intelligence, for instance, there is this big debate, should there be regulation or not? And I'm part of a committee at the Council of Europe on artificial intelligence, democracy, and rule of law. And the aim is to think about an international framework for that, which I think is a very important work. But I fear that time will running out. That's, I think, my main message here, that today, not in all domains, but in some important domains, the developments are so fast that we do not have time to negotiate for, let's say, 5 years, and then another 5 years for, or even more, for the ratification process. So there's a real problem, and in my view, that's why instruments like soft law is an attractive alternative in many parts. Now, then the second characteristic, which we call commitment over form, we tend to think that the legal form is no longer the central part of an agreement. But in the end, that the substance is key. Here again, I would like to give you an example. If you take the recommendations of the Financial Stability Board, I don't know if everybody of you is aware of this board. It gathers the big central bankers in the world. It's a kind of ad hoc forum, which was created at the financial crisis in 2008. And so there are few people establishing recommendations, but these recommendations, of course, are not legally binding, but the effect of these recommendations is huge. And so for this kind of, so this is typically soft law with a big impact. And of course, there is then the question of the legitimacy, which perhaps we could discuss afterwards. Thirdly, the third bullet, beyond interstate relations. This is an easy one. I mean, as Mr. Kaufmann pointed out, the classical model was that international relations is business among states. That's no longer true. There are many actors in this field, and we could say that on a multilateral level, the consequence is that states have shared some of their legislative powers with international organizations, with civil society and the private sector. I mean, if I take a normal multilateral process today, in general, it's always a multi-stakeholder process. So that's a change, and perhaps there's a question we could discuss whether, for instance, as I was working at the OECD, they increasingly had this public consultations, and this is seen as a bigger involvement of civil society and all different actors. And the question is whether this is enough or not. When we talk to our parliamentarians, they do not like to be seen as just a normal citizen, because they say we have a special mandate from the people, and this gives us a special role. And so also on an international level, we are not just a citizen, but we should also have a special role in these processes. Then finally, beyond states' coercive powers. So with this characteristic, we would like to say that rulemaking is increasingly disconnected from the coercive power of states. There are new type of regulatory and compliance mechanisms. And here again, the easiest way to understand what I wanted to say is to give you an example. I guess that all of you know the corruption index of Transparency International. So this is just a list with where the countries are listed, but with a considerable impact on states. So there's nothing legally binding. There's no, you can say, I don't care about this list, but in real life, the impact is huge. Whether a company will invest in your country and so on. So if we come back from this shift in paradigm to the, again, more national level, there we see this tension that on a national level, and I guess in most democracies in this world, they are not built for dealing with non-legally binding instruments. I mean, the whole division of power, the whole legislative process, all this is in the spirit of legally binding instruments. So there's the big question how to deal with that. Perhaps I have also to say that when we were talking to different other governments, I think that that Switzerland is in a special situation on this level, because in many governments, they do not see at this stage the urgency to have this type of discussion, because it's very clear that the parliament has nothing to say when it comes to international relations. So perhaps we can also share about that, discuss this issue. But now in our country, where it is a lively debate about this phenomenon, it's not easy to tackle it. So when I said that we made some proposals, there are some very easy ones, which is to increase the information, to share the information, which means that Parliament is more regularly updated about all these processes we are working on. Which is very difficult with soft law, is that you never know. Let's give you the example of an international agreement. If we negotiate an international agreement, we go to Parliament for a mandate. They give us the mandate and then we negotiate. At the end, we come back and say, okay, this is the result, this is the agreement. Are you okay with it or not? And then there's the ratification process starting. With soft law, you do not know exactly what is beginning, what's happening in the beginning. Quite often you talk about, you start with a new topic. Perhaps in the end you come up with recommendations. Perhaps there's nothing you come up with. And that's tricky, because you can't say to the Parliament, okay, we go now to Paris at the OECD and we will negotiate this type of instrument. You don't know it. And even once such an instrument is agreed upon, you do not really know what happens, because that's again typical for soft law. It all depends on the political power which is put in such an instrument. I also can give you an example which is a little bit more difficult in reality, but just as a picture. There were recommendations done by multilateral on a multilateral level on fighting against terrorism. This was done in the 90s. Nobody cared about it, But after 9/11, suddenly this instrument became crucial in the fight against terrorism. So there's a kind of dynamic in soft law where you can't know in advance in which direction it will go. So it's not easy to deal with this phenomenon. Again, now on the proposals, there are two sides or two levels of possible intervention. The first one is on a national level. I think it's not so interesting for you to discuss this type of proposals because that's quite specific to our system in Switzerland. It's perhaps more interesting to talk about the international level. And so Mr. Kaufmann already gave the example of the European Union. There are examples with the Council of Europe or the OECD, the Organization for Security and Cooperation in Europe. Both have a parliamentarian assembly. So in the international organization, there is foreseen that parliaments can directly work in these organizations, but that's not. That's very rare that you have this type of organization. Then parliamentarians ask us very often, but could we have a parliamentarian assembly at the OECD or even better at UN? There is a big stumbling block that in the foundation treaty, it's not foreseen. So if you would like to create a parliamentarian assembly or parliamentarian delegations at the UN, you have to modify the foundation treaty, which is quite a risky and tricky task. Another option would be that parliaments could be somehow a part of the delegations from the government. That could be an option, but then suddenly you have also a problem of division of labor, let's put it like that. I mean, then the legislative and executive power are sitting at the same table. Yes, and so this is where we are. That's not very concrete, I know, but I think I would stop here and hope that we will have an interesting discussion about soft law.
Thank you very much, Roger Dubach, for this really, let's say, clear picture about an unclear situation. I think it's really showing this tension and this gap we are discussing in a world where democracy has become a universal value, how to deal with these forms of, let's say, lawmaking at the international level, which for a long time has been, in a way, clearly defined who is in charge, who is the decision maker, and then in a way open to, of course, domestic debates depending on the democratic system, more or less democratic. So it has been, as in diplomacy, a way of dealing with each another which has been rather stable. But now we have this increasing gap between the approaches on one side of legality, on the other side of legitimacy, which obviously produce many new forms of international governance, as you have clearly described and shown examples, like the Migration Pact, like the Stability Pact of the banks, like works on terrorism, but also, as you said, in a future-orientated perspective when it comes to artificial intelligence, that these traditional forms are far too slow or in a way too cumbersome to deal with, especially then when it comes to ratification processes. We know that already a little bit from the European Union level, of course, that all these examples about ratifying treaties have become a quite cumbersome exercise, as it in the end maybe goes back to a referendum in Ireland, where a few million people are deciding about a treaty for 450 million people. So these are really exciting, interesting perspectives. You said that the way how this is dealt with in Switzerland is maybe not so interesting, but I think as this is also the Swiss tract of the online forum, and as we all know that in Switzerland, this kind of parliamentarian oversight is also informed by the role of parliament vis-a-vis its people. That means that in many ways, treaties, agreements can, in the case of that many people are not happy with it, be put, in fact, to a referendum, bring back. So it's clear that the parliament also is informed through this reality that it's not, they are not the last to have a say. In many ways, it's possible to put such an issue also to a popular vote. So maybe you could still give us a little bit of insight specifically about how you see this and how the Swiss government deals with that in Switzerland, because that can be informative for others, especially in countries where maybe this kind of participation and direct democracy is under development.
Yes, thank you very much. Yes, as I started just as I just mentioned that in Switzerland, so I think a first lesson perhaps is that how to share information is very key, because up to now many of these let's say soft law processes were just dealt with between governments, and this created this kind of feeling that's not transparent, that parliament but also the public do not know what's going on there. So we try to communicate much more on this, and we established, for instance, lists from the whole administration and the government, lists with relevant soft law processes, and we submit these lists to the parliament. And then there's a commission on foreign policy, and we discuss this list with these commissions. And if there is a particular process they are interested in, so then we give insights about what's going on and so on. And so this is a regularly exercise. I mean, we meet the commissions at least 4 times a year. We also update the lists 4 times a year. And this gives the possibility, as I said before, as you do not really know with the soft law processes in which direction they go, it's important to have a steady exchange of information. Then I think an interesting or an important issue is whether soft law is seen as positive or negative. There you have both views. Some people think that it's positive because, I mean, they regret that there are fewer international treaties, but they say at least multilateralism is still functioning, because in most international organizations, there is also a standardized process for establishing and adopting soft law. Other people think that soft law is the expression of the politics of power, and that just the powerful states are interested in producing soft law, and the rule of law is not respected, and they see soft law more as a danger. And so so you have these you have these both views, which means that in parliament today some parliamentarians would be in favor of somehow adopting soft law, or the kind of a veto that they could say, no, we don't want this one. But if you do that, you give soft law, and somehow if you adopt soft law, you make soft law more or less hard law. I hope you understand what I want to say. And that's the reason why others are against adopting soft law, because they say, okay, we are not involved, but it doesn't count for us as a parliament. So that's the debate, and I mean it's still ongoing. There is no concrete solution in Switzerland now. Of course, as you said, Mr. Kaufmann, if there is a will to more adopt soft law, then immediately you would also have in Switzerland the discussion about referendum. Okay, what type of soft law should you submit to a popular vote, and which not?
Thank you. That's really an important question. And of course, I mean, as you said, the difference between hard law and soft law is a moving target, very obviously. Now we have a few participants who want also to share their thoughts and questions. Daniel Schilly, you have the floor.
Yes, good morning. Thank you very much, Mr. Dubach. So I just thought when you mentioned Switzerland somehow as the small country in the middle of Europe, which sometimes is forced to implement somehow international soft law, then it's for me it's interesting. Many countries, for example, in Africa, they of course feel the compulsion of and power of international trade interests and so on. They have to regulate as those powers are wanting it. And probably the special case of Switzerland are the strong political rights of the people. So yeah, I would like to ask you whether we could, for example, differentiate a little bit between developed, highly democratic countries and their problem with soft law. May it be a good soft law or a more by not so fair, powers-driven soft law, and developing countries.
Thank you. Yes, you may answer, Ms. Duba.
Okay, that's an interesting question. I do not have a straightforward answer to it, because honestly, I didn't really deal with this topic in the context of developing countries. I don't know. I mean, I tend to say that for us as a small country, it's an issue. And I think it's an issue because, as you said, Mr. Schilly, in the beginning, that countries like ours do not have, I mean, we can't influence always these soft law processes. I mean, a very simple example, which I know from my personal experience with the G20, if the G20 decides something, it has a global impact, and it has a global, not always, but sometimes. And then you can't say anything. I mean, you are not asked if you agree with that or not. And I would guess that many developing countries find themselves in the same situation. And so I would guess that the problematic is similar for them. Yeah.
Thank you very much. Then we have a common question from Donald O'Brocklane from Dublin. You have the floor.
Thank you very much, Ambassador Dubac, for that, what to me is an introduction to a new concept of soft law. Mike, you've already touched on the question that soft law will basically be created and implemented, I will say, in the interest of the more powerful states. As far as I'm concerned, the European project is an attempt to bring in checks and balances on just such realities, driven by obviously the experience of the wars of, you know, this century or the last century. Given the Swiss experience over what is now a century, which Bruno referred to, of ensuring that people develop an understanding of the complex issues of international hard law treaties through the referendum, the mandatory referendum process, surely now is the time to apply the same process to soft law, even if it means delays in dealing with some issues. Otherwise, we get autocracies of the more powerful states, fueled, which gives rise then to conspiracy theories and a rise of, let's say, forces that are not interested in ensuring popular understanding of complex issues, and which is the basis of strong democracies.
Thank you, Donald. Mr. Dubach?
Thank you very much for this question and remark. I think I fully agree with you when it comes to the adoption processes or ratification. Once, and that's the important part, once the part before that is cleared, in the sense that, as I tried to point out, the fact that there is a increasing mass of soft law is because it became much more difficult to conclude international treaties. And so you find yourself in the situation where perhaps many countries would be willing to negotiate an agreement on, I don't know, let's say on artificial intelligence. But if you don't have the big countries at the table, and if the big countries decide that they are going to do something else, then it becomes difficult. And so that's what I try to explain with the shift in paradigm, that I think, I mean, especially lawyers like me, of course, we would be very much in favor of continuing negotiating international agreements. But the fact is that it became very difficult. And so finally, actors which find themselves to come up with soft law, it's easier, and they are faster and so on. And that's why if you have an instrument at the beginning which is not legally binding, can you then apply a ratification process as if the instrument was binding, legally binding? And I think that's the difficult question. Just from a purely legal point of view, you couldn't do that at the moment in Switzerland, because there is only ratification processes foreseen for hard law, not soft law. So of course, that's an option. We could change our constitution and to include soft law instruments as well in this internal adoption processes. But I think it's still very important to see the difference of the instrument upfront. But I don't know if I replied to your question. I mean,
thank you very much. I think it's this exactly this this challenge how to enable the participatory elements of democracy in this kind of very challenging and quickly changing sphere. You said before, as an example, that you are starting to make lists on ongoing soft law processes. You are meeting with the parliamentarians on that. You are prepared to give them more information. Do you see, I mean, this kind of creating transparency and information and communication obviously is in any democracy is the fundament of being able to have an opinion, informed opinion, and to be able in the end also to if there is a possibility to say yes and no. Do you see other kinds of this kind of soft democratic initiatives and ways of dealing with that, maybe also in an international perspective? Or is there anybody out there here at this meeting who has this specific kind of experience? Maybe you first, Mr. Dubach.
And sorry, experience on other topics than soft law, or
no, on these kind of initiatives. I mean, you also talked about your experience of consultative processes in international conferences or the OECD. I mean, you have developed the specific way of, I mean, you gave this example of a list which you are creating for the parliamentarians. Are there other of these kind of soft ways of informing and communicating for these issues you know about?
Yeah, thank you very much. I think, as you said, communicating is the most important part for the time being. As I said before, that of course, if there is institutionalized communication with parliamentarians, this makes it much more easier. Also, as I said, if you have the Council of Europe or OEC, then of course, naturally, you are discussing the different topics. And this is not the same if there is no parliamentarian implication in an international process. Yes, I mean, it's very much about these lists and the discussions we have in commissions. And then the current discussion we have is much more about, as I said before, whether the parliament should have more power to decide whether a soft law instrument can be adopted or not. Yeah, so the short answer is, I mean, for the time being, on our level, the crucial element are these lists and the communication we had in the commissions with the parliamentarians. And there was, of course, the parliamentarians asked how other countries are dealing with that. And so we did a kind of research and found that at this stage, as I mentioned, I think that in other countries, it's not really an issue. So in other countries, I mean, we saw, that's also interesting. We saw now in the last 2 years, more publications about soft law. But if you look, for instance, 5 years ago, there's almost no publication on this topic. So I think the phenomenon is there's more attention to this phenomenon. But I have the impression that in other countries, they do not feel at this stage that it's a relevant question. For instance, I was invited to talk about soft law in Austria, but then realized that it's not really an issue. And I mean, for us, Austria is a very close, we are very close to Austria, and perhaps they think that they have the same questions as us, but it was not the case.
It's a very interesting observation, of course, about this urgency and about this, let's say, understanding of a government vis-a-vis its society, parliament, and the people. Now there is a question from Anne Hart.
Hi, good morning, everyone. Yeah, it's probably a very simple question, which you've also touched upon during your presentation, but I was just wondering if you could expand a little more on the role of civil society when it comes to soft law and the introduction of soft laws, and maybe also with regards to the 4 points of paradigm shift that you had in your presentation.
Thank you.
Thank you very much. I think that civil society could play an important role on the international level. And I think the advantage in brackets of the civil society is that you could organize yourself much easier on an international level, or most of the time you are already organized on an international level, which makes it easier to give your voice to international organizations and in international processes. Because this is somehow, I didn't talk about that part now, but if you talk about parliamentarian, you are still in a national logic. And it's more difficult from a national logic to see how to influence international processes. But once you do not have the national perspective anymore, but you are just, as civil society, you are working on an international level for some purpose, it might be easier to bring yourself into these processes. As I said before, for instance, the OECD, they started now, they try to be also more transparent and to have this kind of public consultations. There, of course, as a civil society, you have all the possibilities to intervene. So I think that's the first part of my answer. The second part is when it comes to the paradigm shift. I think that, as I said, there are much more multi-stakeholder processes, that it is easier for civil society to be engaged in these processes. Of course, you should represent, I mean, you have to be organized. It's very difficult to be a civil society if you are not organized, if you're just an individual. But if you are organized, I think you should have good chances to be included in these processes. And I think that's an opportunity, because that's precisely the point Mr. Kaufmann mentioned in the beginning, that in the classical world, if you take the negotiation of international agreements, also multilateral agreements, nobody knew from the civil society what really happens until the end. And so there is an opportunity for soft law processes, because in principle, they are more open in the beginning. So you could be engaged in these processes right from the start. Yeah.
Thank you very much. I mean, this is also, I think it points to the question of intermediation, or those who are the bridge builders, basically, between the institutions, the governments on one side, and the citizens and their representatives on the other side, which is also changing quickly. I mean, it's very interesting to see that, as you have said correctly, that at the international level, as a citizen or a citizen group or as a civil society group, you have often much better access to decision makers, to the center of power, in comparison to back home at the national level, where this kind of openness sometimes is traditionally not existing, especially when it comes to international sphere. We have now a question through the YouTube channel from Erwin Meyer. He asks, could we have a citizen assembly at the UN level like the COP26? which obviously refers to a climate citizen assembly regarding climate issues, but a question of complementing the UN level decision-making processes. Do you have any thoughts on that, Stubach?
Yes, thank you very much. There is one Swiss parliamentarian asked precisely to put this in place. I mean, that Switzerland should be engaged to establish this kind of citizen assembly. Now, as I said, from a legal perspective, this is challenging. I mean, perhaps there are ways to build such a citizen assembly, as you mentioned, the COP. If you want to really have institutionalized citizen assembly, then you would need to modify the treaty foundations, the foundation treaty of the UN, which is a big thing and very, very, very difficult, especially at this time. So my answer would be to say, if there are ways to establish such a citizen assembly, perhaps in a more ad hoc modus, then it could be possible, but very difficult on institutionalized.
Thank you. Now we have a question from Caroline Verneyen.
I actually think Donald has his hand raised, or maybe nobody took it down.
Yes, I tried to give the floor to many different
okay. All right. Yes, so I work for Democracy International, so we co-host this forum. And actually later today, we will have a session on the UN World Citizens Initiative, which is a campaign that we have started, calling for a citizens initiative tool at the UN level that works in a very similar way as the European Citizens Initiative works in Europe, where if you collect enough signatures with a certain quorum of diversity, so in enough different countries, that at least you have to give the floor to those citizens in the General Assembly in this case, and formulate a response. What do you think of an idea like this, or of a tool like this? Is it something that sounds feasible? Is it something that could help?
I have to admit that I'm not very much familiar with this initiative now. So perhaps you can say something more about it, or perhaps I'm just not the good person to answer this question.
Okay, sure. No, so it's the idea is quite simple. It's that if you collect signatures, I believe our idea was 5 million in different member states of the UN. It has a certain key for division, like three African states, 2 Asian states, and so on. That that you can launch a proposal, basically, so a citizens initiative that would have to be heard by the UN General Assembly, and the UN General Assembly would be obligated to formulate a response. And so our idea is that this is also something that can involve civil society more on an international level, and that really can help formulate this like soft law policy, or shape it and give citizens a voice at the international level. So we're just wondering.
Yeah, I mean, from a personal point of view, because I'm not speaking on this now as a government representative, I think that's certainly a good idea. And I mean, to some extent, what I try to show with this shift in paradigm also means that international relations is definitely not a business between states anymore. And so there are many actors, and I think it's important that civil society is organized to make its voice heard. And so such instruments, I think, are very, very helpful. And I think what I see in my professional work is that civil society already plays an important role now in the agenda setting. And yeah.
Yes, I think this issue of agenda setting, in a way, also as it's a soft law by the people. I mean, it's I think this idea of the World Citizen Initiative is also very well informed about the experience of the European Citizen Initiative, which in the end also is, let's say, a soft law proposal in a way that it's not binding on the European Commission to really act on it, while there is a growing, let's say, implication that they should do something or react something. So it's even there moving, while on the other side, this question about reconnecting to the decision making in a way of I mean, the classical term referendum means bringing back the issue to the people from an assembly of decision makers. This has, for instance, created this practice in Ireland, and I would like to give back the word to...
And I just,
yeah.
Would you allow me to just react
Yeah.
to that, because this could be also a complement to the question before.
Yeah.
I think where civil society will plays definitely an important role also is that, as I said, the form is less important, but the substance is more at the heart of soft law instruments. And I mean, the classical model again is that states establish rules, and with the coercive power, the rules are implemented. So it doesn't work anymore with soft law. So an important aspect of soft law is also to think about how can soft law have an effect. So you have to think about, I mean, there's no formal implementation, but you establish soft law in the same way as a legal instrument, because you wanted to change something, you wanted to change a behavior. So as you don't use the coercive power anymore, I mean, not always, but you don't use this coercive power anymore like before. So then you have to think about how this soft law instrument will be implemented. And there you depend much more on the behavior of the people in the end. And this is somehow also civil society. So I think people establishing or producing soft law, they are very much interested to have an exchange with civil society also for this reason. And I think there you would have definitely very open ears from soft law producers if they understand what type of instrument the civil society or people as such would be willing to implement.
Thank you. I mean, that makes me thinking about the current times of corona measures all over the world, where you really can see this kind of, let's say, recommendation measures, which are basically soft law, where the success is based on responsible citizens who are following them, who are taking account of them on one side, and on the other side, these hard measures where you get a fine if you don't stay at home or have a mask. I think this is a very concrete example where we can put it in perspective also, and it's understandable. And of course, this creates a necessity of a responsible society and citizens, individuals, which in a way also goes back to the question of responsible countries and governments. But I would still like to pick up a follow-up question from Donald O'Brien from Ireland about the reconnection of soft law to the people. Donald?
I'm going to pose the question in terms of the extent to which the activities of the European Central Bank in the Eurozone area are considered soft law, and also the extent to which the challenge in Germany that this goes against the mandate of the European Central Bank. Is that a challenge by a, let's call it a civil society group, against soft law and an attempt to turn soft law into harder law through an international treaty? Because we only have referendums here on EU matters because of an action by a citizen who took a case to the Supreme Court in the, I think it was the 90s, based on transfer of powers to the EU institutions, European Community institutions. And the public authorities argued against it because we had a referendum in '72 and said everything was covered. Since then, the public authorities are quite careful in terms of having referendum. We had a referendum on the six-pack, you know, the fiscal compact, even though some people considered it wasn't necessary. And so our governors, powers that be here, seem to almost have conceded that in some senses we have become a referendum democracy in some senses. But the real question is this extending to Germany because of the operations of the European Central Bank, which go against traditional understood German policies on, let's say, monetary affairs? Or have I stretched the concept of soft law too far?
Thank you.
I'm not sure that I got all your points. Perhaps one remark is that I mean there's a huge discussion about a legal discussion when soft law turns into hard law, and so some people think that the soft law can become customary international law. So can if everybody uses it for a very long time, it becomes hard law through as a customary yes, international law. But we think that's happens very rarely. That's not often the case. And then we see much more the importance of soft law for tribunals, courts. So judges tend to use soft law to better interpret treaties. So then soft law suddenly becomes relevant in jurisdiction and has much more legal power through courts. So I fully agree with you that many actions of the European Central Bank could be considered as soft law. Now, when it comes to referendum, I don't think that I fully understood your remark, because again, you should have. It's not easy, as I already said, from a soft law to put in place a domestic process, a kind of a domestic ratification process, like a referendum, which you could also see as a part of a ratification process. But perhaps I misunderstood you.
Donald, did he misunderstood you?
Well, what I'm saying is that the effect of a Supreme Court decision on the constitutionality of the transfer of new powers seems to have given rise to our governors, let's call them that, you know, political parties, politicians, senior civil servants, that any issue of a soft law, or what I would now understand to be a soft law, that may be challenged by the courts, may be challenged by any citizen in the courts here, means that our governors will, as a precautionary principle, almost almost always use a referendum in order to validate soft law measures like the fiscal compact, and that was passed by 60% in the middle of the crisis when we were in a bailout program. And I'm just saying that with the challenges in Germany, in particular, to the activities of the European Central Bank, there could be, that's a powerful country with a strong tradition and a very, on monetary policy. It could mean a new method of transferring soft law more directly by a referendum process into hard law. And the real question is that likely to happen? I mean, Ambassador Dubac has already suggested that the operations of the European Central Bank on Eurozone management seem to be very much like soft law. And the question is, given the practical implications of that for citizens in Eurozone countries, there may be questions of legitimacy. There are questions of legitimacy about this, and the real question is how long that can be sustained without more formal measures of hard law.
Thank you. Any more comment on that, Mr. Dubach?
No, I don't think so, because as Swiss civil servant, I would not like express myself on EU issues.
Okay, thank you. So we have a follow-up question from Daniel Schilling.
Yes, Mr. Dubach, I'm still having a little conceptual problems, because if you, for example, international maritime law is very, very old, because for a long time, for hundreds, even thousands of years, there was the interaction of sea people, and even the pirates developed some rules. You could call it soft law, so some rules of honor and so on. And wasn't it not always the case and was it not always the case that, for example, diplomacy tried to build up frameworks, sometimes for their very difficult leaders? Yeah, for example, Chancellor Bismarck tried to somehow civilize his emperor with other diplomats and others, so to bring things simply together. So is there really a shift in a paradigm shift, or is not primarily the growing together, the global market and the globalization, the real new thing, and probably diplomatic frameworking, was it probably is it maybe a very old phenomena? I'm simply thinking whether the idea of the expression soft law is something very intelligent, but I'm not criticizing you. I'm trying to think what you are saying to us. Mm. Yes, maybe you can comment on this.
Yes, with pleasure. I mean, I just, not to be misunderstood, I'm not here to make publicity or to make marketing for soft law. I'm not, how to say, I'm not a soft lawyer as such. So first of all, the the word soft law is not coming from us, is not coming from Switzerland. It was invented by an American lawyer, perhaps 30 years ago. So it's not a new terminology. And then I think I'm happy for your point, because it's true that if I present the things like this, you could think that the traditional instruments and international agreements doesn't play any role anymore. That's not true. I mean, still today there are many international treaties which are concluded every year. But the question asked by our parliament was to look more into these new, or into these instruments which are legally not binding and called soft law. And at the beginning, I mean, you can have two views. You can think that's you can say soft law always existed, because already I don't know, in the 40s and 50s, I think there were not all instruments were legally binding. And so you might argue that this phenomenon already existed, yes, for a long time, and it's nothing new, and that in the end, the real world is still the legally binding world. And there are many arguments for that. But when we saw how to say, the quantity, I mean, it's not in the end not an argument of quantity, but still, if you look at how many soft law instruments are concluded in the recent years, and then much more important, what I try to give you as an overview with these 4 characteristics, I think that the international order from the Second World War, which was established after the Second World War, is not functioning as it was 15, 20 years before. And so there are reasons to think that we live in another dynamic, and that in this dynamic, soft law instruments are more suited to give an answer to a certain problem, and that it's much more difficult to do it with international agreements. But yeah, that's how to say, that's the big discussion in the end. I mean, I fully agree that you can't reduce anything to soft law.
Thank you very much. Then we have a question from Adam Yara.
Hello. It's not much of a question. I was just a bit of an idea. I was thinking about how possible is it to make sure that soft laws are actually followed? I mean, we've known for a while that the United Nations has had soft laws, but many countries don't adhere to them whatsoever. So, and what is the actual place for soft laws today in a place where not really a lot of countries or institutions actually follow soft laws a lot?
Thank you.
That's a very relevant question because it's about the implementation of soft law. And as I already mentioned before, that the dynamic is very different in this field. So I would say that the usual mechanism is to introduce in a soft law instrument a review mechanism or a kind of a monitoring mechanism where countries which adopted the soft law instrument, for instance, report every 1 or 2 years about the implementation, or sometimes there are also international experts coming into different countries for establishing a report. And for instance, quite of a strict version of soft law implementation is in in the fiscal domain of the OECD, where there are country examinations. So the instrument as such is soft law, so not legally binding. But if you subscribe to this instrument, then you agree that you have to go through a country examination all, I don't know, 3-4 years, which then makes recommendations which are seen by everybody and puts some pressure on the different countries.
Thank you very much. I think we are reaching a little bit the end of our session. I think it was really highly interesting to discuss this issue and to get more knowledge from a point of view of a key player. At the Global Forum, we have in the last 13 years tried to bring together stakeholders, actors, key players on different levels, different issues of democracy. We have developed different kind of tools of, let's say, common understandings regarding these issues, because it's nobody knows the truth. It's really a moving issue, a target. It's often paradoxical. It's difficult to understand, but only through these conversations we, of course, increase our understanding. And for instance, we developed recommendations for politicians and constitution makers when it comes to introduce and establish procedures of participation and direct democracy. For instance, the Global Passport to Modern Direct Democracy, but also in recent years, very much a coordination of stakeholders at the local level, city levels. In 2018, we drafted a Magna Carta for democracy cities, which now develops into an international league of democracy cities. And the question is, of course, at one point also, when it comes to international law, hard or soft, the question of legitimacy and democracy will not go away. It will become stronger. So my question to you is, what would you think if we at the Global Forum would try to, in a way, develop, together with you and many others, some form of a list of dimensions or criteria how to bridge this gap, this growing gap? And if yes, which kind of dimensions do you see would be maybe the key dimensions? Of course, this is an early question. It's a big question, but maybe you have some initial thoughts about that.
Thank you very much for this difficult last question. I mean, just to say that I'm not here to give any answers also to the questions which are asked, in the sense that we are on the way in Switzerland. So we are still discussing with Parliament. We do not have at this stage find a solution, whether it is on the national or international level. So there are the discussion is ongoing, and that, I mean, firstly, I presented this to you as a kind of, we think that the phenomenon is important and we should discuss about it, but it's just to start a discussion and to put the different the different parameters on the table. I think it would definitely make sense to continue this discussion. I mean, of course, it's up to you, but we think that the discussion will continue, and very happy to exchange with you. And I think if on your side you start thinking about how to deal with this type of instrument, that would be very, very helpful, and always a pleasure to exchange with you on that. When it comes to the dimensions, that's quite difficult to reply like this. I mean, the dimensions, I think clearly you have to distinguish between the national and international level. And I also think in this view, the one question which was asked about the role of civil society, I think here again, the question of national international is important. As I said, I think it's easier to approach the phenomenon as a, let's say, an international community, and then ask yourself how, as an international community, we could better influence these soft law processes. And I'm quite optimistic about that, as you said, as different interventions were made, I mean, you could do it as agenda setting, in the agending setting. As I said, also, for sure, there is an interest to know how civil society would be in favor or not, or able to implement an instrument to discuss on this level. So I think this, there I see a lot of opportunities. When it comes to the national dimension, it becomes more, I think the debate is more difficult. I mean, you may all know that if you come to a multilateral level and you say, we have a specific Swiss problem, or we have a specific Irish problem, that's that's always difficult. And in the end, it goes about the substance. It's you have to deal with a problem or with the opportunity, I don't know. And you don't want to talk about a specific national issue. And I think this is the same for international multilateral negotiations. This applies also to soft law processes. And so, as I work for the Swiss government, we are much more on this dimension, but I think that's the hard one. And for sure, if you have any ideas to come up with on the national procedures, as I had the impression that Donald O'Brien had some ideas, that's of course very, very welcome as well. And perhaps in the end, as I said, my perception is that it's very much a Swiss discussion at this stage, and it could be helpful for, I mean, if you would also give some impetus to this discussion, I think that's also the first step to do a kind of awareness raising. And that was finally the aim of my presentation.
Yeah, thank you very much. And you really, I think you reached this goal. I think you gave us an eye opener to a field of challenge, which many people who are in favor and supporting democracy maybe not always have this kind of insight for natural reasons, but which have to do with this kind of idea of democratic legitimization for soft legislation, which is a very, very interesting field and to be continued. I think this panel was very interesting to all of us. I saw there were people from 23 countries participating and listening, and of course it's possible to follow that afterwards and to see it again and to discuss it. Also, as we will have the Global Forum on site next spring in Switzerland, we are in discussion with you, also hoping to see maybe a continuation of this conversation and also some more inputs. We have invited your boss, the foreign minister, for a keynote at the Global Forum next spring. So thank you very much, Mr. Dubach, for taking the time, for being engaged in this discussion with us. And I hope we stay in touch. Thank you very much.
Thank you very much from my side. It was a great pleasure to talk to you about this topic, and very, very open to continue discussing this topic. Thank you very much, Mr. Kaufmann.
Thank you. And this is now the second panel of the Swiss track during this online Global Forum. On Thursday, we will have the third one, which will focusing on the Democracy City. As you know, we will have in spring also the Democracy City Summit, hosted by the Mayor of Bern. And we will discuss these dimensions we already have developed in the recent years together with representatives from other cities. And on Friday, we will have, together with our media partner Swissinfo, a refocusing on the issues of the vote on the weekend, which we started yesterday. So a lot to look forward, and of course also many other panels. And I thank to everybody of you to participate in this, and I will give back now to the technical moderator of this session, Daniela. Thank you.
Yes, thank you very much. And it's great. We're right on time. Thank you again very much, Mr. Dubach, for giving us this food for thought for the rest of the day. Thanks to Bruno for moderating this session, and to all of you for your attention and all your comments and questions. So that's the end of our first session of the second day, but that's definitely not the last. We have 3 more sessions for today. We will now break for lunch until 2 o'clock this afternoon, Central European time. And then we will have a look at democracy in crisis with the panel on Corona dictatorship. So if you're interested in that, please do join us. This Zoom room will stay open, but you are free to leave the room, and then you can come back in the Zoom room using the same link at any time. So I will link the full program again in the chat, and we hope to see you again this afternoon at 2 p.m.